My name is Henry Collins. I'm 61 years old. For 32 years I worked at an energy company in Minnesota. Infrastructure planning. Risk assessment. Capital allocation. I spent most of my career evaluating long-term exposure, studying what could fail 5, 10, 20 years ahead and reinforcing it before anyone else saw the crack forming. When I retired, it wasn't because I was tired. It was because I prefer leaving on my terms. The farewell meeting lasted 12 minutes. A handshake. A folder. A corporate-branded pen. They called me steady. I took that as a compliment. 3 weeks later, I sold my suburban house. Clean transaction. No sentimental hesitation. I had already decided where I was going. A small river home in Wisconsin. Not large. Not impressive. Cedar siding aged to gray. A wooden deck that creaked slightly under weight. The foundation had minor settling issues, nothing structural, just neglect. The previous owner had passed, and the property sat quiet for months before I found it. The first morning I stood on that deck, I heard nothing but wind moving through the trees and water pushing against the bank. No traffic. No neighbors discussing property lines. No obligation. Silence. I purchased it without financing. No leverage. No exposure. Then I began working. Most people treat retirement homes like hobbies. I treat property like infrastructure. If I'm going to live somewhere, it will be structured correctly. I hired an engineer to inspect the foundation. We reinforced it with steel piers and sealed the lower crawlspace. I replaced the heating system with a modern high-efficiency unit rated for Wisconsin winters. Solar panels went onto the south-facing roofline, not for aesthetics, but for long-term cost stability and independence. Then I did something more important. I consulted an attorney. The property had enough acreage to divide legally. So I divided it. The main house remained solely under my personal residential designation. The annex, previously an unfinished storage extension with a side entrance, was converted into a legally compliant, separate dwelling unit. Independent utilities. Separate access. Its own mailing designation. Lease ready. Everything documented through county filings. Recorded. Time-stamped. Additionally, part of the riverbank fell under environmental protection zoning. That meant any structural change, expansion, demolition, new foundation work, required written authorization from the titled owner. That would be me. I did not mention this to my family. When my daughter Megan asked what the new place was like, I kept it simple. It's quiet, I said. Riverview. Small. She laughed. That's adorable, Dad. A little retirement cabin. Adorable. Kyle Brooks, her husband, reacted differently. Kyle works in commercial real estate. Mid-level acquisitions. He speaks in metrics and leverage ratios. At dinner one evening, after his second glass of wine, he leaned back and began advising me. You don't want to tie too much capital into fixed rural assets at your age, he said. Liquidity matters more in retirement. I listened. I nodded. I have managed 9-figure infrastructure budgets. I let him continue. You'll probably end up needing assisted support eventually. Being out there alone isn't ideal. Eventually. I noticed Megan watching me while he spoke. Not interrupting him. Not disagreeing. Just observing my reaction. I smiled and changed the subject. Over the next 2 months, small comments accumulated. You're really far out, Megan said during one phone call. What if you fall? I won't. You don't know that. I do. Silence. Then Kyle again, at a family barbecue. Property taxes in Wisconsin can creep up. might not be the smartest long-term hold. I asked him if he'd reviewed the county assessment caps. He hadn't. The comments were never aggressive. Never direct. Just positioning language. Distance. Safety. Practicality. Then came the first real indicator. Kyle called on a Tuesday afternoon. No small talk. My parents are selling their place, he said. They'll need somewhere temporary. The river house makes sense. Temporary. He said it like a conclusion already reached. You should probably think about downsizing, he added. Closer to town. More practical. I sat at my kitchen table, looking at the river moving steadily past the dock. I see, I said. You don't need all that space, he continued. It's just you. Just me. I did not argue. I did not defend. Come by Saturday, I said. We'll take a look. He paused, slightly thrown off by the absence of resistance. Good, he said. Glad you're being reasonable. After the call ended, I walked into my office and opened the fireproof cabinet. Inside were the finalized land division filings. The annex lease template, market rate, security deposit required, fixed term. The environmental zoning restrictions with highlighted sections detailing owner consent requirements. I placed them neatly on the desk. Preparation is not emotional. It is administrative. Later that evening, Megan texted. Kyle's parents might bring some things. Just while they settle. Settle. Language reveals intent long before behavior confirms it. I responded simply. Understood. Saturday at 10 works. That night, I reviewed the property layout again. Driveway entry monitored by exterior camera, compliant with state privacy law. Secondary entrance recorded. Timestamp retention set to 90 days. I confirmed the annex had a separate lock and documented key issuance. No shared interior access point remained. I had sealed that during renovation. Every angle considered. On Friday evening, Megan called again. You're not upset, are you? She asked. About what? About helping family. I believe in clarity, I said. She hesitated. Kyle just thinks it's logical. Logical. Men like Kyle confuse access with entitlement. Saturday would not be emotional. It would be instructional. I woke before sunrise and brewed coffee. Sat on the deck and watched fog lift from the river in layers. I did not feel anger. Only confirmation. There is a particular tone people use when they believe you are declining. When they assume silence equals weakness. When they interpret restraint as confusion. I have spent decades assessing structural stress. The early signs are always subtle. A hairline crack in concrete. A slight shift in load distribution. A repeated question framed as concern. By the time collapse is visible, it has already been engineered. I was not going to allow collapse. At 9:58 a.m., I heard a vehicle turning onto the gravel drive. Right on time. I stood, straightened my shirt, and walked inside. On the kitchen table, neatly aligned, were 3 folders. No raised voice would be necessary. Just documentation. Kyle arrived at 9:58 a.m. Not alone. 2 SUVs rolled into the gravel drive, Kyle driving the first, a rental moving van behind him. His parents sat in the second vehicle. Boxes visible through the rear windows. They had not come to look. They had come to occupy. I stepped onto the porch before they reached the front steps. The morning was cold enough to keep voices sharp. Kyle smiled first. Morning, Henry. No, Dad. He reserves that for public settings. Morning, I replied. His parents emerged from the second SUV. Martin and Elaine Brooks. Early 70s. Well-dressed. Controlled expressions. They surveyed the property the way buyers assess foreclosures. Elaine smiled politely. It's charming. Charming. Kyle gestured toward the van. We figured we'd save time and just bring a few essentials. No point making multiple trips. I watched him as he spoke. His tone wasn't hopeful. It was procedural. Decision already made. You brought a moving truck, I said calmly. Temporary, he replied quickly. Just until they settle. Settle. Martin stepped forward. We won't be in your way. We'll keep to ourselves. I nodded. That's good. Kyle exhaled, slightly relieved. He interpreted neutrality as consent. Let's head inside, he said, already turning toward the door. I did not move. The annex entrance is on the side, I said. Kyle stopped. Annex? Yes. He frowned, glancing at Megan, who had just stepped out of his SUV. She looked uncertain now, the first crack in confidence. I walked inside and gestured toward the kitchen table. Before anyone carries a box, I said, we should review structure. Kyle remained standing. His father removed his gloves slowly, studying the folders laid out in front of them. I opened the first. This property is legally divided, I explained. Primary residence and separate rental unit. Recorded with the county 3 months ago. Kyle blinked. Why would you do that? For flexibility. I slid the annex documents across the table. It is an independent dwelling. Utilities separated. Market rate lease. Fixed term. Security deposit required. Background screening standard. Silence. Martin adjusted his glasses and skimmed the header. Elaine leaned in. Kyle's jaw tightened. We're not tenants. Correct, I said. You are not. Then why are you showing us a lease? Because occupancy requires documentation. Megan shifted her weight. Dad, this feels formal. It is formal. Kyle tried another angle. Family doesn't charge family rent. Family doesn't arrive with a moving truck without confirmation, I replied. His mother stiffened. We assumed, she began. I know, I said evenly. That's the issue. Kyle leaned forward, palms on the table. We talked about this. No, I corrected. You informed me of your plan. The distinction landed. Kyle straightened and changed tone, less polite now. You're alone out here. This makes sense for everyone. We help you, you help us. I don't require help, I said. That's not the point. It is exactly the point. He glanced toward the windows, calculating. The river house had appreciated significantly after renovation. He knew it. I could see the assessment behind his eyes. You don't need all this space, he pressed. Mom and Dad downsized. It's temporary. For how long? I asked. A few months. 6. Maybe. 12. Kyle hesitated. There it was. Martin cleared his throat. Our condo sale is delayed. Market issues. Of course, I said. Elaine tried a softer approach. Henry, we don't want conflict. We thought this would be a natural solution. Natural solutions are discussed before trucks are rented. Kyle exhaled sharply. So what are you saying? I'm saying, I replied, tapping the second folder, that the annex is available under lease terms. Or not at all. Megan looked at Kyle, uneasy now. You'd charge my parents rent? She asked quietly. Yes. Kyle laughed, short, disbelieving. You're serious. I am. Martin set the papers down carefully. What's the rate? Professional. Controlled. He understood numbers better than emotion. I quoted it. Market accurate. No inflation. No discount. Elaine inhaled. That's higher than our old mortgage. Then perhaps alternative arrangements are preferable. Kyle's patience fractured. This is ridiculous, he said. You're choosing paperwork over family. No, I said. I'm choosing clarity over assumption. He paced once across the kitchen. We already told our realtor we had housing arranged. That was premature. Megan's voice trembled slightly. Dad, why are you doing this? I looked at her, not angry, not hurt. Because entitlement grows where boundaries fail. Silence settled over the room. Kyle stared at me as if recalculating a projection he had misread. You think we're trying to take advantage of you? He asked. I think, I replied evenly, that you believed I wouldn't object. He said nothing. Outside, the moving truck engine idled. Finally, Martin spoke. We didn't anticipate this level of resistance. It isn't resistance, I said. It's structure. Kyle picked up the lease packet and flipped through it more aggressively now. What's this clause? He demanded. Unauthorized alterations to protected land carry penalties. Penalties? Financial and legal. Elaine's expression changed. Subtle alarm. You put environmental restrictions on this property? They were already in place. I ensured enforcement language was clear. Kyle looked up sharply. You've been planning for this. Yes. The word landed without emphasis. For the first time since arriving, uncertainty replaced confidence in his posture. Megan folded her arms. So it's either we sign your lease or we leave. Yes. Kyle stared at me for several seconds. You'd really let your grandson's grandparents struggle instead of adjusting? I would let adults make responsible arrangements. The engine outside shut off. The driver had stepped out, waiting for instruction. Kyle turned toward the door, then back to me. This isn't over, he said quietly. I'm not looking for it to be. Martin placed the documents neatly back into alignment. Elaine, he said softly, let's discuss alternatives. They stepped outside. Kyle lingered. You're making a mistake, he said under his breath. No, I replied. You are. He left without another word. I stood alone in the kitchen after the vehicles reversed down the gravel drive. The house was quiet again. But something had shifted. Escalation rarely ends with a single failed attempt. It adapts. I gathered the folders and returned them to the cabinet. Then I reviewed the exterior camera footage and archived it. Because if they escalated further, and I suspected they would, I intended to be prepared. Kyle did not call for 3 days. That was expected. Men like him retreat only long enough to reorganize. On the 4th morning, Megan called instead. Her tone was softer. Calibrated. Dad, can we just talk calmly? She asked. We already did, I replied. It doesn't have to be legal. We're family. It became legal when you arrived with a truck. Silence. Then, Kyle's parents are in a short-term rental. It's expensive. I'm aware that housing costs money. You're being cold. No. I'm being clear. She ended the call quickly. Too quickly. That told me the next move would not be conversational. It came a week later. Certified mail. Inside was a notice drafted by an attorney representing Martin and Elaine Brooks. The document asserted an implied familial occupancy agreement and claimed that I had verbally approved temporary residence during a prior phone conversation. Implied. I read it twice, then set it down. There had been no approval. Only my instruction to come look. They were attempting to manufacture consent retroactively. I called my attorney. Not a local generalist, a property litigator I had retained during the land division. A man who understood documentation more than drama. I forwarded him the letter and the archived camera footage of their arrival with the moving truck. He called back within an hour. "They're probing," he said. "Testing whether you'll fold." "I won't." "I know. But we respond properly." We drafted a formal reply denying any occupancy agreement and reiterating the annex's independent rental status. Attached were certified copies of the property division filings and environmental restrictions. I insisted on including time-stamped still images from the driveway footage, the moving truck visible behind their vehicle. Not to int *mid-8. To document intent. The response went out the next morning. 2 days later, escalation resumed. This time through a different channel. Adult Protective Services. A courtesy inquiry regarding my well-being and independent living capacity. Anonymous complaint. I almost admired the sequence. First, assumed access. Second, implied consent. Third, question competence. It was textbook. I scheduled the visit immediately. The social worker arrived on a Tuesday afternoon. Young. Professional. Clipboard in hand. She walked through the house. Noted the renovations. Asked direct questions regarding my finances, medication, daily routine. I answered each without defensiveness. When she finished, she closed the folder. "There's no concern here," she said. "You appear fully capable." "I appreciate thoroughness," I replied. She hesitated before leaving. "May I ask, is there a property dispute involved?" "Yes." She nodded once. That was enough. After she left, I added her visit report to a new folder labeled, Pattern. Because that's what it was becoming. A pattern of strategic pressure. That evening, I reviewed my financial accounts. Not because I suspected intrusion, but because vigilance must remain constant. Everything intact. However, one detail caught my attention. 3 days before the Adult Protective Services inquiry, there had been a login attempt on my online banking from an unfamiliar IP address, out of state. Blocked automatically. I contacted my bank's fraud department and requested the access log details. The attempt had originated from a commercial VPN service. No attribution possible. But timing matters. I changed every password. Enabled multi-factor authentication on every account. Then I did something Kyle would not expect. I commissioned a background review. Discreet. Legal. Thorough. Kyle's real estate firm was solvent, but leveraged aggressively. 2 projects underperforming. 1 investor lawsuit pending. Martin and Elaine's condo sale had indeed stalled. Not market conditions. Liens. Unresolved medical debt and a tax dispute from 3 years prior. Their temporary relocation had less to do with convenience and more to do with financial compression. Pressure seeks relief. And I owned a debt-free river property. I did not confront them with this information. Not yet. Instead, I refined my perimeter. I updated the lease terms on the annex to include a mandatory financial disclosure requirement for prospective tenants. Standard language, but precise. I re-verified the environmental zoning with the county and obtained an updated enforcement letter affirming owner-exclusive consent authority. Then I waited. Escalation rarely ends quietly. It escalates further when early attempts fail. 2 weeks passed without contact. Then, on a Saturday evening, a black sedan pulled into my driveway without notice. Kyle stepped out alone. No moving truck this time. He approached slowly, hands in pockets, posture controlled. "I'd like to reset," he said once we were seated at the kitchen table. "Go ahead. My parents are under financial strain. The condo issue is worse than we expected." "I'm aware." His eyes narrowed slightly. "You've been digging." "I prefer information." He exhaled. "Look. If they can't stay here, they're looking at selling assets at a loss. That is unfortunate." He leaned forward. "They helped us when we started out. And now you intend for me to help them. That's what families do." I folded my hands on the table. Families also disclose liabilities before requesting shared residence. He didn't answer that. Instead, he changed direction. "What if Megan and I moved in? Sold our place? Combined households? Long-term planning." There it was. Not temporary. Not 6 months. Permanent consolidation. Access to a debt-free asset under the guise of multigenerational living. "I'm not relocating my autonomy," I said. "It's practical," he pressed. "You won't live forever." A statement. Not concern. I looked at him evenly. "That's correct. Which is why my estate plan is already finalized." His expression shifted. "Estate plan?" "Yes," I continued calmly. "The property is secured under a revocable living trust with conditional transfer provisions." He went still. "Conditional?" he asked. "Very." He understood enough to recognize that control would not pass easily. Kyle stood up slowly. "You've thought about all this?" "Yes." "You don't trust us?" "I don't trust pressure." He left without another word. I watched his car disappear down the road and felt no anger. Only confirmation. The next move would be less direct. When entitlement fails through negotiation, it searches for leverage. So I prepared leverage of my own. I scheduled a formal review of the trust with my attorney and added a clause: any documented attempt to coerce occupancy or challenge capacity would trigger automatic disinheritance. Not symbolic. Enforceable. Then I notified my bank to flag any external inquiries about property valuation or title status. 2 days later, my attorney called. "They've contacted a different lawyer," he said. "Attempting to explore contesting your mental fitness through probate pre-challenge." "They're early," I replied. "Yes," he agreed. "And they're reckless." I closed the call and stood at the window overlooking the river. The water moved steadily, indifferent to manipulation. Preparation is not aggression. It is insulation. And I had insulated everything. They believed I was alone. They believed age meant erosion. They were about to discover the difference between solitude and vulnerability. Kyle made one final mistake. He assumed escalation could remain private. 3 weeks after our last conversation, I received notice that a petition had been filed in county court requesting a competency review and temporary financial conservatorship, in the interest of family protection. Filed by Kyle Brooks. Not Megan. Kyle. The petition alleged cognitive decline, isolation vulnerability, and erratic financial structuring. Erratic. I read the document without emotion. He had attached selective excerpts from my land segmentation filings and referenced my refusal to house his parents as evidence of impaired judgment. He underestimated 2 things: documentation and patience. I did not react publicly. Instead, I expanded the field. First, I instructed my attorney to file a formal counter-response including full medical clearance from my primary physician, neurocognitive evaluation results, which I obtained voluntarily within 72 hours, financial solvency statements from my bank, property valuation and structural audit confirming improvement rationale. Then I added something Kyle did not anticipate: A forensic timeline. Attached were time-stamped security footage of their arrival with the moving truck. The certified letter asserting implied consent. The Adult Protective Services Inquiry Closure Report. The unauthorized banking login attempt log. Pattern. Not accusation. Pattern. The hearing was scheduled for the following Tuesday. I attended alone. Kyle arrived with counsel and an expression that attempted composure. The judge reviewed the filings for 12 minutes before asking a single question. Mr. Brooks, she said, did you arrive at the petitioner's residence with a moving vehicle prior to securing written occupancy agreement? Kyle hesitated. Yes, Your Honor. Did you subsequently file a complaint alleging incapacity after refusal? Silence. Yes. She turned to my attorney. Is there evidence of financial impropriety by the petitioner? No, Your Honor. Quite the opposite. She scanned the cognitive evaluation summary. I see no basis for conservatorship, she said finally. Then she did something Kyle had not calculated. She ordered the court record to reflect the filing as unsubstantiated and potentially retaliatory in nature. Public record. Kyle's counsel requested dismissal without prejudice. Denied. Dismissed with notation. The room was silent. I did not look at Kyle. I didn't need to. But exposure was not finished. Court dismissal ends a petition. It does not address motive. 2 days later, my attorney sent formal notice of intent to pursue legal action for malicious filing and attempted coercive conservatorship. Simultaneously, I executed the trust amendment clause. Conditional disinheritance triggered by documented coercive legal action. Megan was notified in writing. Not emotionally. Administratively. Her call came that evening. You're cutting us out? She asked, voice shaking. I am protecting the estate from manipulation. It was Kyle. You endorsed it. Silence. You're destroying this family, she said. No, I replied evenly. I am preventing its erosion. She began crying then, not theatrically, but genuinely. For a moment, I allowed myself to feel it. Then I closed the space again. This was avoidable, I said. You chose escalation. She hung up. The final piece required precision. Kyle's professional vulnerability. During my background review, I had uncovered an investor lawsuit tied to his firm. Allegations of non-disclosure in a mixed-use development project. Nothing criminal. But unstable. Through lawful channels, I submitted certified copies of the conservatorship dismissal and retaliatory notation to the managing partners of his firm, not as revenge, but as disclosure of litigation risk involving one of their senior associates. I did not editorialize. I attached court documents. Within 10 days, Kyle was placed on administrative review. Within 30, reassigned away from client-facing acquisition roles. Reputation in commercial real estate relies on perceived stability. A failed conservatorship petition suggests instability. Especially when publicly recorded. Martin and Elaine never contacted me again. Their tax lien surfaced in county filings 3 weeks later. Their condo sale proceeded at a loss. No one mentioned the River House. Megan attempted one final visit. She arrived alone. No SUV convoy. No rehearsed positioning. We sat on the deck facing the river. I didn't think he would file something like that, she said quietly. You knew he was pursuing legal options. I thought it was negotiation. It was coercion. She stared at the water. He said you were isolating yourself. I am selective. He thought you were slipping. I am deliberate. Another silence. I didn't want to lose security, she admitted. There are many forms of security, I replied. Control is not one of them. She nodded slowly. I don't know how to fix this. You don't fix trust, I said. You rebuild it. Slowly. She left without hugging me. Which was appropriate. Months passed. The river moved through seasons without commentary. Kyle's firm downsized during restructuring. His name disappeared from their public associate list. I did not inquire further. My estate plan remains intact. The annex remains available, under lease only. The environmental restrictions remain enforceable. And the trust clause stands. Some would call it harsh. I call it architecture. Because families, like structures, fail when load-bearing elements are quietly removed. Silence is not weakness. Preparation is not paranoia. And aging is not surrender. I did not raise my voice. I did not threaten. I documented. I responded. I insulated. And when exposure became necessary, I allowed facts to speak where emotion would have weakened the outcome. The river house is still mine. The deck still creaks slightly under weight. The mornings remain quiet. But the difference now is clarity. They understand something they did not before. Peace is not negotiable. Autonomy is not transferable. And mistaking restraint for decline is an error that carries consequences. I am 61 years old. I reinforced the foundation before anyone else saw the fracture. Because experience teaches one simple truth. The most devastating response is never loud. It is thorough.